right? So here we go. So yeah, as Janine mentioned, I'm Gill Loomes-Quinn, and I'm the co-director of the Open Justice Court of Protection project. And I'm here today to do this second second seminar for you guys. The first one was back in July. They're sort of the same, pretty much the same content. So it's, if you were there in the first one, you're going to be hearing, similar stuff today. They're not, they don't build on each other or anything. But we're running this again today to tell you about open justice in the Court of Protection. So how members of the public can get involved with observing the Court of Protection, how you can get involved in watching Court of Protection hearings, and a little bit about the project and what we do, and how we can support with observing Court of Protection hearings and perhaps writing about them from our blog, and what all of this open justice, what it does for society, what it does for disabled people, what it can do for you, particularly for people from different professional backgrounds, especially in health and social care, what you can learn, how it can work in terms of your professional development and things, and how you can contribute. So that's what we're talking about today. The main objectives basically are for you to find out about open justice in the Court of Protection, how you can observe, and to know a bit about the project, the Open Justice Court of Protection project, to have links to our website and such, to know how you can find us, and basically to know how you can get involved further after today. So those are the main aims. Just it's a sort of a general bringing this to your awareness and hopefully getting you interested and excited, and wanting to be involved a little bit in the project. So just a little bit about the project and some background before we get going. Basically, the Open Justice Court of Protection project was started by Celia Kitzinger, Professor Celia Kitzinger, and myself back in June 2020, which, if you think about it, was quite significant in that it was just about the time when lockdown was starting, when a lot of things were becoming remote, and Court of Protection hearings were no exception, and the remote nature of proceedings really has been kind of at the centre of what has made so much participation in court proceedings, I think, both necessary and possible. Our project started basically at some initial concerns about the fact that that taking proceedings online might have actually shut out some observation of the court, made it kind of less transparent than it had been. In reality, that's actually been the contrary has been true, and the fact that we can now observe the court from our homes or our offices, I think has increased the potential and the actual number of participants. So that's the kind of background behind how the project got started. Since then, we've supported thousands of people to observe hearings. We've published hundreds and hundreds, literally hundreds of blogs on our website, which now stand as a resource, as a teaching aid, and as a record of the different proceedings that have been observed, and the different range of perspectives and contributions that members of the public from all different backgrounds have made in discussing court proceedings, and the impact that has had on general public understanding of the court and the interaction between the court and the public. So yeah, it's been a big deal, a big learning curve, and massive steps forward in terms of raising awareness of the court and the power it has in the lives of disabled people who were deemed to lack capacity. So moving on, yeah, I've kind of already covered this, but this is just kind of what we're going to look at today. So bit about the Court of Protection and why transparency of the court is important, bit about our project and what we do, and how you can find us, a little bit about the experiences of some other observers who've worked with us to observe the court in action and kind of what they've got from it, and then just a bit to conclude about why you should maybe consider observing the court in action, and perhaps writing a blog post for us, what you can get from it and how you can contribute. As I've said, there is plenty of time, or there will be plenty of time for talk and discussion at the end of when I finish talking. So getting firstly to think a little bit about the background of the Court of Protection and of how the idea of transparency sits within the court and the development of the Court of Protection. I'm going to kind of I'm guessing that probably there will be people here who are very familiar with the role of the Court of Protection. If we've got any social workers who have experience of working with people deemed to lack capacity, of capacity assessment, or any best interest assessors, or maybe anybody with kind of an IMCA background or anything like that, there's probably going to be a lot that you're going to be very, very familiar with already. But I'm going to try and sort of give an overview just so that anybody who's maybe not as familiar, who's maybe more towards the start of their career, or who has maybe not had that experience with that particular area of work, that, you know, we're not going to leave anybody behind. So please, you know, if I'm telling you stuff that you already know, just kind of sit back and relax for that bit, and appreciate that it's there for maybe for other people. So the Court of Protection was established in its current form by the Mental Capacity Act 2005. Prior to that, there had been a Court of Protection, a court that was called the Court of Protection, that dealt with people deemed to lack capacity, but really it only focused on financial decisions. So one of the key changes that happened around with the introduction of the Mental Capacity Act 2005 was that the new Court of Protection began to deal also with issues relating to health and welfare of people who were deemed to lack capacity. And the court makes determinations about mental capacity. So one of the things that it can do is, where there's a dispute about whether a person lacks capacity to make a specific decision, the court will be the kind of final arbiter of that decision. And then if a person's deemed to lack mental capacity, the court makes best interest decisions on behalf of incapacitous adults. So that's again in situations where best interests processes have not been successful prior to involvement with the court. An application will be made, and that's when the court will be the one to make the decision, the best interest decision. And the court deals with making decisions on behalf of people with a range of impairments. So disabled people maybe experiencing dementia, learning disability, or autism, or a range of kind of psychiatric impairments. And the largest disabled population by far that is represented in proceedings in the Court of Protection are those who are experiencing dementia. So as we can appreciate, there's going to be an awful lot of us who are either going to become potentially involved with or have decisions made on our behalf by the court if we experience dementia as we get older. You know, we're an aging population, or it might be that our family members, loved ones, are impacted by that as well. So it really can, you know, the court can potentially become involved in anybody's life kind of at any point. And the court covers kind of a wide range of cases, so deals with a wide range of kind of decisions, from health and welfare to property and affairs, and deprivation of liberty under the deprivation of liberty safeguards. So if you think about that, there's pretty much any area of your life, any decision that you as a capacitous person might make in your own life, the court can potentially make that on behalf of somebody who lacks capacity. So it has a massive sphere of interest and a massive range of impact on people's lives. And it has significant implications for ideas of disability justice and the rights of disabled people, not only in terms of the impact on the autonomy of disabled people, but also in terms of being the final implementer of the rights of disabled people, particularly in terms of kind of best interest and access to services and support. The court sits in London, so sometimes in front of Tier 3 judges in the Royal Courts of Justice, or also in First Avenue House, where the actual Court of Protection is found, on the 5th floor of First Avenue House in Holborn. And the court also sits in the regions. So, for example, you know, the nearest one to me would be Leeds, and there are specific regions that are dealt with and administered by hubs, and yeah, we can observe in all of those courts. Particularly, we're kind of particularly interested in observing what's happening in the regional courts, because they're the ones that can kind of be a bit forgotten and not subject to scrutiny. A lot of the time, hearings that are in the Royal Courts of Justice that are maybe more kind of seen as more interesting to the general public will perhaps attract the attention of the media, the press, but really, obviously, all of these, you know, all of the courts are important, or scrutinising them is important in terms of open justice and in terms of kind of yeah, seeing what's going on and learning from all of those courts. So there are approximately 30 hearings scheduled per day across the different court buildings where the court sits. One thing that does happen, though, and it's important to sort of bear in mind if you're interested in observing the court in action, is that quite a few of the hearings that are listed for any given day will actually be adjourned or be vacated, so they won't actually happen at very short notice. Often that's because the parties will reach agreement, meaning that the hearing doesn't actually need to happen, because, you know, a lot of the discussions and the consultations are happening right up to the point at which, you know, the hearing is set to go ahead. So, you know, things can change quite rapidly, and often that can mean that if we're planning to observe a certain hearing and we're just about to kind of get ready and go and sit down and watch it, we'll find that actually it's not happening, it's not going ahead. So it's always a good idea to kind of have a reserve plan in mind. If you set that time aside for observing a hearing, it's always a good idea to have maybe a couple, you know, at any given time that you might be looking to observe. This is just an important point about the numbers of published judgments that come out of the Court of Protection. So one of the main ways, other than actually going and seeing what actually happens in a court hearing, the only way in which we as the public can find out about decisions that the court makes, that any court makes, is through the judgments that are published. The number of judgments that are published by the Court of Protection every year are very low. So we see in you know, in 2021, 2022, there were 65 judgments that were actually published by the court, and that means that there's not very much that we can look at to find out about what's actually going on in the court. Also, obviously, judgments are written from a specific perspective, from a legal perspective, and for a specific reason, kind of to reinforce the reasoning of a judgment, and for the judge to kind of show they're working legally. You know, there are lots of other reasons why we'd want to observe the court in action, but you know, even so, that is a very low number. So there's a very small, narrow sliver of all the hearings that happen in the court throughout a year where a judgment will actually be published. Other than that, the only way in which we can find out about what's going on in the court and learn from it is actually by going along and watching. So that's a little bit about the Court of Protection. Thinking about the idea of transparency in the court and why it matters, it's possibly a kind of a strange thing sometimes to think of, particularly in relation to the Court of Protection, because often we're kind of rightly concerned with ideas of privacy and with protecting the privacy of people who are at the centre of proceedings. But balanced alongside that is the idea of kind of public interest and the right to know what public bodies, including the courts, are doing kind of on our behalf. So thinking about open justice, I really find this quote quite powerful in terms of summing up the principles of why open justice matters. So, you know, in the case of the Guardian News and Media, Lord Justice Toulson put it like this. He said, open justice, the words express a principle at the heart of our system of justice and vital to the rule of law. The rule of law is a fine concept, but fine words butter no parsnips. How is the rule of law itself to be policed? It is an age-old question, quis custodia ipsus custodes. Who will guard the guards themselves? In a democracy where power depends on the consent of the people governed, the answer must lie in the transparency of the legal process. Open justice lets in the light and allows the public to scrutinise the workings of the law, for better or for worse. Or Jeremy Bentham, in a well-known passage that was quoted in Scott and Scott, said, publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself, while trying, under trial. So I think those quotes kind of set out that really in a democracy, and you know, in which we all live in a democracy, and those are the principles under which we've decided to live as a society. And I think these quotes just really set out that for all of us, we have a role and a responsibility in that democracy, in upholding democracy, being part of that. And part of that for us as citizens can be something such as going and actually witnessing the powers of democracy being implemented, being exercised, you know, watching court proceedings and holding public bodies to account is quite a powerful thing. It's a powerful exercise of democratic power. I've certainly found it myself, you know, as a disabled person myself. It's quite powerful to be able to watch public bodies being held to account, either by the court who is holding a particular public body to account, or, you know, for myself as a member of the public to be able to watch court proceedings and kind of watch those in action and comment on those in the form of a blog or a tweet. It's an exercise of having a voice kind of as a citizen, and that's a powerful thing, and those are important principles, and they're principles that only work in practice if all of us take them on board and take on board the responsibility. So that's some of the kind of the principles stuff, the kind of the general, you know, the high level sort of theoretical, political kind of values and ideal stuff. But what of the practicalities of transparency? So, I mean, firstly, it's possibly worth pointing out, and I thought I should have a slide somewhere about transparency in the Court of Protection. But for those people who kind of don't, actually, if you don't mind, I'm just gonna skip out of there and see if I can find. No, I'm very sorry. I seem to have lost the slide. So what it's probably worth reflecting on, and I'm sorry I don't have a slide that deals with this, is that the Court of Protection has really had a very has kind of had a bit of a learning curve, I'd say, in terms of its relationship with transparency. So when it was originally set out under the introduction of the Mental Capacity Act 2005, the assumption was that the majority of proceedings before the court would be held in private. There were some exceptions to that, so decisions about serious medical treatment or about committing people to prison would be held in public, but the general rule would be that, much like the family court, the Court of Protection would sit in private. Then, for various reasons, including some of the legal cases that I quoted from just before, there was a move towards greater transparency, and in 2016, the Court of Protection introduced its transparency pilot, and that reversed the presumption. So rather than it being presumed that the majority of hearings would be held in private, it was presumed that the majority of hearings would be held in public, subject to specific reporting restrictions, which are set out for each hearing in what's called a transparency order. And that is a court order that we as members of the public are bound by if we decide to observe court hearings. And that order sets out what it is that we're not allowed to say in relation to the proceedings that we observe. So usually the reasons underpinning the transparency order are to do with protecting P, so the person lacking capacity at the centre of the case. They're to do with protecting that person's anonymity, so it's things to do with that the person's identity or the identity of any of the person's family members, where the person, you know, the person's address, or the fact that they're subject to those proceedings. And yeah, so those are certain things that we're not allowed to say, and it's actually quite daunting sometimes. The language of the transparency order is kind of in it's very sort of dense legal language, and actually it's you know, if the breaching the transparency order is classed as contempt of court, and you know, the transparency order tells us that we can, you know, be subject to having our property seized, assets seized, or we can be committed to prison. So, you know, it seems daunting, and one of the things that we've done as a project has been to kind of support people with understanding that, and with actually kind of having the confidence to feel supported to kind of go ahead and have a voice and have a say on proceedings, and not be kind of put off or deterred by, you know, by the sort of the legal implications of that. And you know, although we are members of the public ourselves, you know, we're not lawyers, but we do kind of try and just support with that through our own experiences as public observers, and through some of the you know, the relationships, the contacts that we've built up around the Court of Protection. But yeah, so that was what happened in 2016, that the shift towards transparency that was then kind of brought into a sort of more permanent footing a year later. And actually Part of my PhD research was that I went and sat in First Avenue House in London, which, as I mentioned, is where the Court of Protection sits in London. And I went and spent a month there and observed hearings under the transparency pilot as an observer. And that was kind of my first experience of kind of experiencing what I could get out of, you know, learning about the Mental Capacity Act and how it worked in practice. It was absolutely fascinating. It was one of the most interesting kind of experiences of my my working and my academic life, and that was where I kind of got the bug for this. And you know, OJ Cop kind of followed, but yeah, so that's kind of a brief potted history of what transparency is and how it's kind of come about in the Court of Protection. Some of the practicalities though, because as ever, you know, there's the principle, there's the theory, and then there's how things work in practice. So some of the practicalities to do with transparency in the Court of Protection. One thing is that the listings in the court, so you know what's going to be heard in a specific day, are only made public at very sort of short notice. So they only kind of, the lists only come out in the sort of the late afternoon or the evening of the day before any hearing is to be heard. So if we want to actually go along and observe something, or you know, decide to observe something from home, we can only look at the listings the night before and see what it's possible to observe. So it's not possible to kind of think, you know, oh, I'd like to observe a certain type of hearing. Will there be one next week or next month or something? It is very short notice. And that kind of has an impact on how we sort of go about, you know, deciding, you know, setting aside time to observe and kind of being broad-minded and a bit kind of open to what we want to see and things. And that's the kind of thing that we can support with and help people to kind of plan and make the most of the time that they've got to observe, because you know, we're all, you know, we all know that as kind of busy working people, setting aside time to do this, it's important that we make the most of that time, that we don't kind of find that we're, you know, we've set aside the time but we end up not actually being able to use it effectively. But that is one issue. It's the sort of the short notice of how listings actually work and how that relates to open justice. As I mentioned before, quite a few of the hearings that are listed actually don't go ahead at the last minute for very good reasons. You know, it's generally, you know, it's a good thing if parties reach an agreement and the hearing doesn't need to go ahead. It's you know, it means that court time is used the most efficiently. It's often the best thing for the person at the centre of the hearing. What's not so good is when hearings don't go ahead because the parties on either side haven't actually got to a position where they've done what they've been asked to do, or you know, there's been delays in terms of what local authorities are supposed to be doing in relation to a person's life or something. That's another big reason for delays. But either way, you know, we have to bear in mind that that you know, Court of Protection lists and the hearings are very much a movable feast. One thing that we found about the listings though is that often the details that are listed for any hearing are inaccurate, and that's one thing that we as a project do. We keep a note of inaccuracies in the listings, and we engage with HMCTS, the Court and Tribunal Service, about the listings and where mistakes are being made. Often again, there's a lack of information, so things like time estimates for how long a hearing is going to be, details of the case, the different types of decision or impairment that are involved, and you know, that can be quite a difficulty in terms of planning what to observe, what to, you know, how to make the most of your time. And as with pretty much any other public service, the courts are under-resourced, they're understaffed, court staff are under pressure, they're overstretched, and those are all things that we try really hard to bear in mind when we're kind of working with court staff. The approach that we take as a project is very much that we work to support the judicial aspiration for transparency. So the Court of Protection itself has said, including, you know, the vice presidents at various times of the court have said that they have a commitment to transparency, that they want to be open, that they want to support people, members of the public and anyone to scrutinise the work that they do. They want to kind of welcome us in, and in order to do that, we see ourselves as very much kind of facilitating that and making it into a kind of practical reality. But, you know, we're working with people, court staff kind of on the ground, who are very much under-resourced, overstretched and often quite stressed. And, you know, that can lead to things like delays in responding to observers' requests. So I mentioned, you know, listings come out at very short notice. That means that if we want to pick a hearing to observe, we have to email the court kind of the night before the hearing and you know, basically ask to be sent the remote link to observe a hearing. And sometimes, because of the pressure that the court is under, staff won't actually get back to you with the link. Sometimes, you know, that it's not in time for you to be able to actually watch what you'd planned to observe. And those delays can be really frustrating. But again, that's something that we as a project try to keep a record of, keep track of, and draw attention to, because obviously drawing attention to the practical problems of the system of transparency is as much kind of part of the work of transparency as, you know, the actual observation itself. Sometimes it seems like really kind of, it probably sounds like I'm talking about really technical, tedious kind of, you know, details, and it's attractive to kind of sometimes think of, you know, the principles of a particular campaign or of a type of work that you're doing, and to think in terms of the politics and the grand ideas. But often sort of grand ideas will fall and fail on the details and the practicalities. And one thing that I think we found as a project is that a lot of the time it's the grunt work of kind of admin that is really central to upholding the idea of transparency. There can be delays in judges kind of receiving requests, different requests that might be made in terms of transparency. And the, you know, access arrangements can be very last minute. Delays in terms of the start and finish times of hearings. It's sometimes, you know, it looks like we've got a court list that have set you know, times you expect a hearing to start at 2, for example, but you might actually find sometimes that the judge might have several hearings listed at that time, or the judge might have had a prior hearing that's run over, or, you know, for various reasons, things often don't start on time and consequently don't finish on time. So again, it's important to be flexible, and to kind of you know, set aside enough time that you know you've got time to kind of, you know, go with things as they kind of unfold on the day if you're wanting to observe. One thing that we can facilitate is if you want to observe in a specific geographic location, maybe because you're working in a certain area, and you want to see what the court in that particular area is doing, or maybe there might be a particular judge that you want to observe for a particular reason, you know, particularly if you're supporting people, working with people who are going through court of protection proceedings. You know, sometimes we support people who, you know, professionally are involved in court proceedings, or who maybe have loved ones that are going through court proceedings, or even maybe themselves are subject to matters before the court, and they want to observe another hearing, a different hearing, and to kind of prepare themselves for what that might actually be like, you know, the kind of the procedural aspects of what happens in a court case, you know, maybe particularly see how a certain judge behaves, how they talk to people, you know, how they kind of you know, listening to people, listening to witnesses, give evidence, for example, can be a really powerful learning tool if you yourself, you know, as a social worker, if you're going to be giving evidence yourself in a different case. Those are all things that it is possible to facilitate and that we can help with. So that's really useful to know, I think. Oh, my slides are frozen for some reason. Here we go. So where a hearing's listed, if you want to observe a hearing in the Court of Protection tomorrow or next week, where might you find the listings? Well, there are 3 places. There's actually not, there's more than 3, because there's our website and our Twitter account, but in terms of where the court publishes its lists, there are 3 places. So there's the Family Division of the High Court, the Royal Courts of Justice, and that has its own listings that come out every day, and the link for that is there. I'm assuming that Janine is going to be able to share these slides with you after we finish talking today, so all of these links that I've got in the slides you'll be able to access, hopefully. So that's where you can find out about Court of Protection hearings. That's the list for the whole kind of the whole High Court. So you know, you have to kind of look through that and find the Court of Protection and the family courts within that list. There's also the First Avenue House listings. That's got its own list, and that's the link for that is there. That's actually, I'd say, the most kind of detailed and comprehensive one, in terms of it actually tells you about what issue is going on in a particular hearing. So, you know, for example, if you're interested in observing a hearing concerned with dolls, you know, like a Section 21A challenge or something like that, the First Avenue House listings actually will tell you those kind of issues that are going on, and it's also much better on kind of time estimates as well. The regional courts, as I mentioned, you know, your specific regional courts, they're listed in their own place on a database that's called CourtServe, and that's CourtServe is mainly designed for lawyers, kind of to check, you know, what's going on with hearings that they themselves might be concerned with. CourtServe is free to use, but you need to create your own account if you want to look at CourtServe. It's got its own section, its own heading for the Court of Protection, but it's also quite unreliable in that sometimes Court of Protection hearings don't make it to the Court of Protection tab. They're actually just listed under the geographical area. It's another of those kind of details, those practicalities that, you know, we keep track of, and it's kind of a tedious problem, but it is a kind of impediment to kind of the practicalities of open justice. But those are the 3 places where the courts actually publish their lists for Court of Protection hearings. In terms of how they're listed, these are the kind of things that you see. So as I sort of mentioned, you know, different degrees, different amounts of information available. So the top left one is a regional hearing in Newcastle. You can see that it tells you the date, it tells you the judge that is hearing the case, it gives you the case number, it gives you a start time, it doesn't give you much else. And there's a similar one below for Truro. That one tells you that it's a directions hearing, and it tells you that it's going to be by telephone. Again, not kind of much else. One on the right hand side is one that gives you a bit more information. So it tells you, this one tells you again about the issues that are going to be, that are, you know, the court's concerned with. So where peace shall live, healthcare, deprivation of liberty. Tells you that it's a public hearing with reporting restrictions, so that's the transparency order that I talked about. CVP is the cloud video platform, so that's one of the remote platforms that the court uses. So yeah, and then below there's the sort of the link and the phone number that you can get in touch with if you want to observe. So that's kind of roughly what you might get, you know, if you look at the listings. And you know, the listings are kind of a bit, you know, that they're maybe not that user friendly for members of the public. That's one of the things that we found, and one of the things that we've kind of tried to do is to make the listings kind of more readily accessible to members of the public through sharing information about hearings through our own channels and through our website or our Twitter, which I'm going to talk to you about in a second. And we also try and sort of translate some of the jargon, so that you know exactly kind of how to observe what, you know, what sort of platform is going to be used. We sort of tackle tackle abbreviations, you know, like CVP, for example, or things like that, and try and make them a bit more kind of accessible to kind of members of the public. So, you know, don't worry if this looks kind of very stark and a bit you know, not that helpful. For our purposes as members of the public, it's actually not the most helpful. So yeah, transparency is an important principle. It's important. It's also important for us, you know, for people who work in fields that are related to the Mental Capacity Act, social workers, health and social care professionals. We, you know, there's a lot for us that we can get out of observing the court in action. A little bit of extra background about kind of why I'm interested in court proceedings and in how the court works is that my work background before I kind of went into academia was in advocacy. So I worked as a community advocate for several years, specifically with autistic people, and I wasn't an IMCA. I went into advocacy at just the point when IMCA became a thing, but I was a sort of a general universal advocate. But some of my clients were subject to court proceedings in various ways, and the Court of Protection was something that was relevant in the lives of some of my clients. But at the time, this was, you know, pre-2016, the court was very much a closed door, and it seemed kind of, it was very difficult to work with clients and support clients who had this kind of presence in their lives, this power that was making decisions in their lives, but that was very opaque to me. And I think that if I'd have had access to the court as a member of the public, if I'd have had a project like we have now in OJCOP to be able to support me to watch the court and to see how it worked procedurally and the types of decisions that it made and how it came to those decisions, I think it would have made me into a much better advocate and would have made me much more able to support the people that I worked with who were subject to court proceedings. So, you know, there's the sort of the high level, you know, the sort of the democratic principles, but there's also the kind of the values of our jobs and our professions, those of us who work in health and social care areas that are impacted by mental capacity law. There's, you know, us wanting to be good at our jobs and to support the people that we work with. And so this all leads us to the Open Justice Court of Protection project, who we are, what we do, and kind of why we do it, and how we can perhaps support you to you know, to develop the skills and the understanding to do your job as well as you can. So the project, we promote open justice in the Court of Protection. As I mentioned, we were launched in June 2020. Some of the things that we do, so as I mentioned, we share court listings. I've already shown you that court listings themselves are a little opaque. They may be difficult to locate. So one of the things that we decided would be a good idea would be if we took it upon ourselves to bring together into kind of one place court hearings that you can go along and observe as a member of the public, put them on our website so that you don't, and we now have, there's a team of kind of 4 or 5 of us, and one of us each day trawls through all the listings, including all the different regions on CourtServe, and pulls out the hearings that are before the Court of Protection that we could potentially observe, and puts them onto our website and onto our Twitter feed. And basically we do that so that you don't have to. So we've created kind of a location, kind of a bit of a one-stop shop for the for members of the public who want to observe. We provide information and practical support to public observers, and that includes through our website. You know, we have that area that is called a public observer wiki on our website, that has information and things, and we also have an email address and a contact button on our website, and we are very responsive and very supportive of people who want to observe. We report on hearings that we've observed. As I mentioned, we have, you know, hundreds of blogs on our website now that kind of discuss individual hearings, as well as kind of explainer posts. So we have lawyers and different professionals who have written us posts that kind of explain the work of the court, key aspects of what you might see. So it's a learning resource in that respect as well. We provide links to published judgments. We're concerned with one of the things that really kind of exercises us and has been a key concern for us over the years is the fact that often the majority of court protection business is not reported by the media. When it is, as with most legal reporting, it is often, well, it's incomprehensive and sometimes inaccurate, and often goes for the headline rather than for the sort of the accuracy angle. And often, as kind of you'll know or you'd imagine, the types of decisions that the court is making are very nuanced, very sort of specifically tailored to the life of an individual, and that's not sometimes brought across well in kind of a media, you know, a newspaper article. So we really want people to actually have to engage with actual judgments and to see the actual text of the judgment itself as well. So we do link to judgments wherever we can. As I mentioned before, there are not many of those, but we also share updates on developments in the Court of Protection. So yeah, that's another thing. And we use our experiences of the impact of the development of the Court of Protection. We use our experiences to feed back to the court about what they might do better. I'm afraid I've just noticed the time. I'm really sorry. I felt like I had loads more time, but I got a bit sidetracked. We also, as I mentioned, we tweet about hearings, as well as we tweet our blogs as well. So if you wanted to follow us on Twitter, or X as it now is, you can find us at Open Justice COP. Again, you'll have the link to that. And our website. So our website publishes court protection hearings. We have featured hearings every day. So that's your kind of one-stop shop to go to. We provide support and information. We have a wiki which has got links to key kind of blogs and things that you can read. That's the website. We developed this feedback form because often it can be quite difficult to kind of structure your observations to kind of make sense of what you're watching. So we've got a downloadable form that you can fill in, that you can either just send back to us as it is, as a kind of record of what you've seen, or it can be the sort of the bones of developing a blog if you want to write something up. And as I mentioned, the blog, over 350 blog posts since June 2020, probably a lot more now, as well as kind of explainers that we commission on aspects of court of protection practice, as well as kind of project news, things that are going on in our project. Observers' experiences. I'll just read one of these because it's really about time I finished talking. So this is Louise Burrell, a social worker who observed a court of protection hearing, and this is what she had to say about it. She said, "Human rights has become real and applied through observing the court in action. I can see more clearly that down at the coalface, we have real opportunity to empower our service users. And based on what I have observed, I have confidence that if the situation of our service users should ever require consideration by the Court of Protection, The judge will ensure their right to participate is facilitated and their right to self-determination, if at all possible, is respected. So that was kind of quite a positive experience of being kind of positively impressed by the work of the judge there. I'm just going to skip those. Yeah, I'm going to skip that as well. These are all things that are really just different people, different professions talking about different reasons why they found observing the court particularly beneficial to them. Another kind of reason why it's important, you know, what we can get from observing is the idea of informed critique. So sometimes we see things that we see decisions that the court makes that are difficult decisions, the kind of things that often do make it onto the sort of the front pages, you know, decisions about, for example, preventing P from having sexual relations, or maybe compelling P to have medical treatment against their wishes. They sound really, really controversial, but in actually observing the court in action, we can have an informed critique. You know, going from the headline to what actually happens is often quite a big step, and in watching the court in action and engaging with the judgment, we can have a much more informed kind of discussion and debate about key social issues, and that includes kind of decisions that are that the court itself makes. So there's a blog post here by 2 clinical psychologists, including Claire Martin, who's now a member of our core team, and that was kind of a decision about covert medication that they actually really I think took kind of wanted to critique. So they did that via the blog, and obviously some of the sort of critique can happen on Twitter as well, and we kind of engage with Twitter and try and kind of inform the debate there. Different reasons, just to finish off with, why you might like to observe the court in action. You can see justice being done. It's public scrutiny of the court. You can learn how the court may work with your clients and how the MCA 2005 might be applied. It's continuing professional development, and some professionals have actually used court observation as CPD time. You can see how witnesses are engaged by legal professionals. You can observe professional roles and interactions, develop legal literacy and work on embedding this in public and political contexts. You can engage in debates from a more informed perspective, understand the nuanced, textured and contextualized background to a case, and contribute to public advocacy. And also the court has personal impact. 6 million people per year are impacted by the MCA 2005, either as P or as a carer or family member. A small proportion of those directly encounter the COP, but you need to understand its role in the grand scheme. So many times people find themselves at the centre of court proceedings, maybe of a family member of themselves, and the court and the whole MCA process is completely new to them. Through these kind of observation roles and increasing public awareness, we can kind of prevent that or mitigate it. That is further details and contact of kind of how to get in touch with us, how to find us. And I am very sorry because I have used up all our time talking, haven't I, Jeanette? Janine, I am very sorry about that. I got quite sidetracked.
No problem. Thanks, Jill. We'll end the recording now and we'll